let's hit fair use for a minute and then move on to a few other topics. Generally, the author of a work has exclusive rights for a set period of years to control the use of the work. The set period of years thing is so complicated as to be incredible. There's a couple of great online resources. Let's see what I have here. There's one called the Copyright Digital Slider, just librarycopyright.net, librarycopyright.net. There's also at copyright.cornell.edu. If you just search for Cornell and public domain, you'll get this. There's a chart. Here's how many pages it takes to explain whether or not something is in the public domain because of how old it is. And right now, the only thing you can be comfortable in saying is that a work from before 1923 is in the public domain. And that's assuming it's the version of the work from before 1923 and not a copyrightable new arrangement of the work or version of the work or translation of the work. Beyond that, you need to look at the chart or even talk to a lawyer. It's questions turn, the answer to the question, is this work published after 1923 now in the public domain and usable without clearance, turns on whether it was published in the US or elsewhere, whether it was published with or without a copyright notice. Until 1978, copyright notices were required when you published a work. Since then, you don't have to put one on. You will want to put a C in a copyright on everything that you produce and the year you produced it and who's claiming it to put the world on notice, but you no longer have to do that to have a valid copyright. You did it one time, so was there a copyright notice? Was it unpublished? Was it published? Was it registered? Was it published? And then was the registration within a certain number of years? Was the author anonymous, or did the author publish under a pseudonym? Was it prepared certain countries have special arrangements. Works from certain countries that have not signed on to the Berne International Treaty don't enjoy any copyright protection in the U.S. Works prepared by an officer or employee of the U.S. government in the course of his or her regular employment duties don't have any copyright. Complicated area. But assuming something is covered by copyright, you can make an argument, I'm not infringing because I'm making a fair use of that copyrighted material. The concept of fair use has been around for 150 years. It was a judicial concept until 1976. And what had developed in the court was that if you were using somebody else's work for purposes such as criticism or comment or news reporting or teaching, scholarship, research, you're in an area where you can argue that your use of the work's not an infringement. And the four factors that have been identified by the courts over the years are the purpose and character of the use, including whether it's of a commercial or non-commercial nature, although you can have a commercial fair use. That's just one factor along the way. The nature of the copyrighted work, is it a highly creative work? Is it a newspaper article and facts that 3 days later really, the expression of those facts didn't hold any particular, it didn't show any particular creativity, it was time had passed, or is it something like a piece of music or a play that is highly creative? The amount and substantiality of the portion you used in relation to the copyrighted work as a whole. And number four, the effect of the use upon the potential market for or value of the copyrighted work. And underneath this whole thing always is the court looking at whether or not you proceeded in good faith. Was your intention to take somebody else's work and capitalize on it, or were you taking their work to illustrate a point you were making? Were you transforming the work? Were you taking, was it a transformational use where you were taking somebody else's work product and incorporating it in a way that made something more of it rather than just capitalizing on what they had done. So the hope, everybody's hope had been when it came out that there was going to be a codification of all this 130, 120 years then of judicial rulings in the statute, everybody's hope was it would be very clear. Instead, what happened was Congress just repeated what the courts had been saying over the years and didn't really much clarify anything other than to say these are the factors that should be looked at. There had been, I think, a trend towards narrowing what could be used under a concept of fair use. And you're on both sides of the equation, of course, because you want to use other people's works. You probably don't want them using your works very much, or you may not want them. I think things have been swinging towards a stricter reading of fair use. About 5 years ago, though, after a couple of years of work, the Documentary Filmmakers Statement of Best Practices of Fair Use was issued in 2005. If you put in Documentary Filmmakers Statement of Best Practices, you'll get this, you'll pop this up. So part of fair use is generally when the courts look at a claim of infringement is what's the standard in the industry. So this was an attempt by documentary filmmakers to set a standard in the industry that courts could refer to, and some have, saying here's how we interpret the four criteria that are in the law, and here's how we would like documentarians to apply them. And they look at employing copyrighted material as the object of social, political, or cultural critique, quoting copyrighted works of popular culture to illustrate an argument or point, capturing copyrighted media content in the process of filming something else. This could be Elvis in the background if you didn't stage it, but rather as you're filming something in the community, there happens to be a TV on in the background, or there happens to be a car rolling by with a song blasting out. And using copyrighted material in a historical sequence. And they go through in some, so this may be helpful as the years go on. So far, not cited often, but development. Yes, sir?
You mentioned part of fair use is whether you're a news organization. I've always been confused about this dumb question. Are public television stations considered news organizations?
The premise is often the question, because you don't have to be a news organization. One of the areas in which you can make a fair use argument is if you are reporting news, but that's not required. Most times fair use doesn't relate to someone being a news organization. So you don't have to reach that question, but let's go to that question for a second. There's no good answer right now what's happening. I think that a public television organization that produces a news program or produces news documentaries is clearly a news organization to that extent. The question has arisen now because you have cases where bloggers say, I want the advantages, whatever they are, that a news organization would get, whether it's with respect to fair use or reporting. In some states you're allowed to, some states and not others, there's a law that insulates you from defamation claims if you were trying to do a fair report on a public issue. Is a blogger eligible for that? And so far it looks like the Supreme Court has in one case has said a blogger, you don't get credentials as a news organization. You can say, I am a news organization, I am reporting the news, I am offering critical commentary on current events. You're covered, but it's an open issue as to where it's going. In some situations, the Supreme Court has said a blogger is just as good as the New York Times. In other situations, we don't know yet. Public TV station, I don't know why you wouldn't be. I think if you say I'm doing news reports, you're a journalist.
You know, half of us, we air the news hour, but we don't have a newsroom, and that's where the confusion comes for me.
I see. I think the fact that you air news hour, if you had a program that wasn't at all, if you had an entertainment program and you use somebody else's work in it, I don't think you could lead off by saying, well, I'm a news person because I air NewsHour. That doesn't. The question is, what are you doing with respect to that particular production, not characterizing you overall. I think anyway. There's some basics. Yes.
Another question. Let's say that you went into a classroom to record footage for use by teachers in professional development product. And in the course of teaching the lesson, the teacher uses a popular song, a contemporary popular song. Would that be considered fair use under?
Fair use is whatever a court says, but boy, I'd take that case on. That couldn't be a stronger argument for fair use.
So that would be fine.
In the course of teaching activities, and presumably the teacher's using it for
to make a point in the
to
lesson.
make a point. Yes, that's fair use. You're there.
Okay, but would that be all right for any type of distribution, like on CD or in a repository online?
If I were advising you on it, I might want to know a little more, but I would say yes.
If you show the whole program?
When you say you show the whole program, what's at issue here is that particular song, right?
Right, it was a song that
Okay, I
was
thought her
being-
follow-up question was, would that pertain to showing like a whole program?
Well, I think if you took that program that incorporates a song, I don't know what part of the song the teacher's using, but say the teacher's taking a full minute out of a 3-minute song.
That's correct.
To illustrate something. If that's fair use, it's fair use, and the fact that it's being distributed later as part of the whole program doesn't undercut it. There was a Detroit case actually about 15, 20 years ago on just that point, where there was a less music in it, but it was a little piece of music that was incorporated in the show. It was a program designed sort of social consciousness for teenagers or something, a very high-minded program, and there was a suit about the music, and it was a small amount, but the answer was, yeah, that can be distributed any way they want to because it's solid fair use.
Okay, what about the lyrics, the printed version of the lyrics of the song in accompanying material, educational material aimed at teachers?
I would want to see how much it is and how it's used. I think, again, you'd have a good fair use argument, I think. It always helps in fair use if you're using no more than what you need to make the point. So if the teacher is sort of slacking off by playing 6 popular songs to keep the kids entertained and then making a point for 30 seconds about it, that's one thing. If you're taking 1 minute of a popular song and then spending 10 minutes analyzing it, that's another thing. So the question is, how much are you taking, how are you using it?
Well, Larry, you could take a full song.
You might well be able to justify a full song.
And use it as a educational.
Absolutely. You know, I'm saying it's a sliding scale here, where the less you use, the easier it is to make the case. Absolutely, you can have a full song if there's a reason to use the full song instead of just a part of it to make the point.
We had to shoot part of the performance for a program that we were doing, Children Dancing, and the background music was the Nutcracker Suite. And
You got a problem there. You have a potential problem there with if it's ballet is considered to be a dramatic use, same as opera would be a dramatic use, where the music combined with the dance is telling a story, providing narration. That's different.